Hi, everybody. Welcome. Thank you for joining us today. As everybody's coming in, please feel free to use the chat and introduce yourselves. When you introduce yourself, feel free to offer your name, your agency, where you're calling in from today. We'd love to know who's joining us. And if you would like to activate the closed captioning, you can do so by clicking the Show Captions button on the bottom of your screen. And while you're doing that, let me introduce myself. I am Kimberly Richards with Justice System Partners, and we are hosting today's Pet Network webinar about supporting individuals most likely to miss court. And so to kick us off, I just want to give a little backstory about what the Pet Network is for those who may not know. So as you may be aware, I'm sure, jails have become warehouses for people who are poor, people who lack sufficient housing, or who may suffer from mental illnesses or from addictions. And so this starkly reflects America's long history of racism. But jails are misused, they are overused in ways that damage families, that devastate communities, and ultimately lead to more crime. But in 2015, the MacArthur Foundation launched the Safety and Justice Challenge, which aims to change the way America thinks about and uses jails. The foundation has invested in over 40 local criminal justice systems across the country that are working to improve public safety, eliminate racial and ethnic disparities, promote stronger, healthier communities, and reduce the financial costs associated with incarceration. And so the Safety and Justice Challenge, or the SJC, invests in locally developed equity-based solutions that take a balanced approach to protecting public safety. Their goal is to support policies and practices that will safely reduce jail populations by 50% across all safety and justice challenge jurisdictions by 2025. Now with that, and as a part of the SJC is the Pretrial Equity and Transformation Network webinar series. And the PET Network is a peer learning network where the goal of the series is to elevate SJC sites engaging in meaningful front-end transformation work and provide opportunities for other sites and jurisdictions to learn from this work. And so this series is bringing together technical experts, people with lived experience, practitioners to discuss new and promising programs and practices and just share the lessons learned for us all to grow from. So with that, just want to do a brief overview of what today's agenda will look like. First, we definitely want to talk about the data. We want to unpack the evidence behind court's most frequent utilizers. And from there, we will have two presentations of our sites that have graciously agreed to speak about their amazing, innovative work with us. We will have the Most Visible Persons program, which is shared from our guests from Charleston County, South Carolina, and then the Queen Supervised Release program shared by our guests from New York City Criminal Justice Agency. Following that, we will have a facilitated discussion with Q&A. There is a Q&A feature where you can submit questions to the presenters. We encourage you to use that feature. You are able to upvote questions that you're most interested in. Panelists can also respond in the Q&A feature, but we will try our best, to save time to respond to those questions later on in the webinar. And the chat is also open if you would like to add commentary or participate in the conversation. So if you want to use the chat, if you want to use the Q&A feature, either one works, but we really recommend that you do so because your experience matters, your insight matters, your questions matter. So with that, I will turn it over to my colleague, Shannon Magnuson from Justice System Partners to unpack more of the evidence behind helping individuals to get to court.
Awesome. Thanks so much, Kimberly. I really appreciate it. I'm going to give you 1 second to share my screen. So today I'm really going to kind of start us off, and I'm really excited about this webinar, and I'm really excited about the folks that have joined us today. We're really going to spend today kind of unpacking the evidence about how we help people get to court. And so, one of the things that we know is that folks can remain detained at any point in time during the pretrial process. Immediately after booking, they can remain detained. They can access release at some point in time. But we also know that when folks remain detained, even for one day, there can be disastrous consequences like loss of income, loss of housing, and just generally other kinds of issues. We also know that when folks are detained after booking, that it can have collateral consequences on case processing outcomes. We understand that when folks are detained, that they tend to plea faster, they tend to receive harsher sentences at a sentencing hearing, including more likely to receive incarceration sentences, and they're more likely to receive probation sentences for even longer if they remain detained. And so we know that there is a push to release people as soon as possible. And what we're finding is that in more cases than not, folks are getting released at arraignment or initial appearance. And then often those options could include being released on your reconnaissance. Folks are also sometimes assigned to pretrial supervision. Sometimes they're also sometimes assigned electronic monitoring or GPS. And then sometimes folks are assigned kind of UA testing. And there's some things that we know about these or about these release options. There is research that exists about them. And what we know about them is not that good. In fact, related to pretrial supervision, there's a lot of mixed effects. And what that means in the research community is that there have been different studies. In this case, there's been over 8 studies in the pretrial supervision space that are really studying the effectiveness of pretrial supervision to increase court appearance and decrease new arrests while on pretrial supervision. And what the research says is that sometimes it does and sometimes it doesn't, and it's really rather inconsistent. In particular, what we found is that sometimes when it does increase court appearance, it's actually unclear if the reason why it's in fact increasing court appearance is because people are actually receiving technical violations for not complying with monitoring as part of pretrial supervision, receiving bench warrants, and going back to jail. So what we're finding is that pretrial supervision might be successful in increasing court appearance, but actually it might be doing that because it's inadvertently creating delayed reincarceration during the case processing outcome. What we also learned is that urine analysis testing also has mixed effects related to increasing court attendance and decreasing new arrests while on pretrial. And what we find is that for folks that test negative, they tend to come to court. And for folks that test positive, they don't tend to come to court. And this really feels kind of rather intuitive. And so what we're finding is that UA testing, particularly in a population that has severe substance use disorder, is unlikely to be able to stop immediately upon booking and during case processing, they're going to continue using, and that the presence of UA testing during the pretrial process really creates extra pressure and stress, and folks are actually unlikely to show up to court. And what we find here with electronic monitoring is actually weak effects, which not only means that sometimes it does and sometimes it doesn't, it actually means more often than not, it does not increase in ways that we want it to. It doesn't achieve the outcomes. Electronic monitoring we don't find that it improves court appearance or that it reduces technical violations. There might be other important reasons to use electronic monitoring or to be using GPS monitoring, but related to increasing court appearance, what we're finding is that these options, in particular electronic monitoring, they don't really cut the snuff in terms of helping us kind of help people get to court. And ultimately, what we know is that the good news is that regardless of the ways in which we assign people release, whether that's ROR, on pretrial, or on UA testing or EM, that more often than not, people do get to court. This is really great news. On average, there's not a lot of really good national data on this, but thinking about using kind of data that we have here at JSP related to pretrial validation tools, what we're seeing is that by and large, across some of our sites, about 75% of the populations that are moving through their court process are getting to court without ever receiving a bench warrant. And to be frank, if you told me that in your jurisdiction it was even higher than 75%, I would absolutely believe you. These numbers are just averages. And by and large, what we do know is that more often than not, people do get to court without a problem. What we also see is that there is some folks that do miss a hearing or two, and that they at least receive one bench warrant. And generally, some of our data is suggesting that this might sit around 15% of some populations. If you told me it was less in your jurisdiction, again, I would absolutely believe you. We understand that lots of spaces have different levels of tolerance for absence or tardiness, and that might play into how folks receive bench warrants or don't receive bench warrants. And so ultimately, we know that across the country, there's about 15% that receive at least one bench warrant, but it absolutely could be lower. But what we're really focusing on today is this population. People who are receiving more than one bench warrant, who are receiving more than one bench warrant during a singular case, and that are consistently missing court. And we know that for this population, there might be something characteristically different about them. And so the question here then is, if more people are getting to court and even fewer people are not getting to court, then why are they not getting to court? Why are our typical release options of pretrial surveillance, of UA testing, of electronic monitoring, why isn't it working? And ultimately, what we're starting to find is that those options, when we release people after arraignment or initial appearance, they don't fundamentally address why people don't get to court. A handful of years ago, JSP conducted a study in combination with Lake County, Illinois, which was very exciting, to learn more about why people miss court. And what we did was we partnered with the Public Defender's Agency to interview folks that were currently in custody with a bench warrant and only a bench warrant. And we simply asked them, why didn't you get to court that day? And these are some of the answers that they told us. I think if you think about these answers or look at these answers, there's nothing new here. I don't think I'm telling you anything that you haven't seen or experienced in your own home jurisdictions. People are by and large navigating these other life responsibilities. They're managing family, they're managing housing instability, they're managing their mental health and their substance use. And for many folks, they're serving as primary caregivers on top of all of that. We had a handful of people in our study that also were navigating logistical issues of getting to court, whether that was transportation concerns, information concerns about just not understanding when or where their court hearing was, how to access Zoom or other online portals, or just on having an address or a driver's license, right? There was lots of these concerns, of which I'm sure you're also experiencing in your home jurisdictions. Another area that people really talked about as being another reason why they missed court was these kind of like past experiences that were really driving this inability to get there. And this had considered this idea that like they find the court process overwhelming or intimidating, or they're fearful of outcomes, or it was confusing and there was conflicting information and too much information. And people, frankly, had just already experienced racism, ableism, and stigmatizing experiences, that moving in and out of these court spaces was so overwhelming and debilitating, it actually prevented them from getting there. And I'm sure that this is going to sound like it sounds like some of the people that are navigating your court processes. They're going to sound like stories that you've heard before. We met one person that was talking about how they had rented a room and they were moving between houses, and then they started working the night shift. And quite frankly, that even when court was a big responsibility for them, that they ultimately just could not manage the situation. They couldn't manage all of the things that they had going on. For folks that were really navigating these logistical issues or technical concerns, just found people that like didn't understand the technology or was confused or didn't really just understand how to navigate where to find themselves. And so ultimately, even when they did show up, they weren't counted as showing. And again, here talking about past experiences of what people are experiencing. This person was coming from out of state, and so is navigating. Lake County is on a border on the border of Wisconsin. So they were coming from Wisconsin. And they said, that was an issue for them. And then also that their judge intimidates me and that makes me cry. And it's not unpleasant to attend court. And whether or not we agree that these are legitimate or illegitimate reasons to get to court, we agree perhaps that court is probably not a pleasant experience. The reality is that at the end of the day, these are the reasons why people do not get to court. So if we want people to get to court, then we have to be thinking about all of the reasons that they're not getting to court and then planning for them. But what we found in the work that we did is that while many of the people that were sitting in jail at the time of our research had experienced these big three issues, the people who had reoccurring challenges, who were consistently missing court, who were consistently getting picked up for bench warrants, they had what we consider compounding challenges. And for these folks are really navigating something much more extreme. In this case, we had an individual who was homeless and had to go to the library to be able to access his shelter that day. And unfortunately, if he left the library to go to court, he would have lost his shelter for the day. And so he made a decision to stay at the library instead of going to court. And what we're finding, or what we found in our study, for most of these people that were having reoccurring challenges to get to court, that kind of 10% of people, these are the kind of survivalist decisions that they were making. That even when they were choosing not to come to court, that they weren't necessarily making those choices in a vacuum. That instead they were making those choices in context to the other things that they were navigating. And for many of these folks, they were just navigating life and basic survival, and in this case, shelter. And the reality here is that we're not typically asking folks to come to one or two hearings. We tend to ask folks to come to a lot of hearings, which means that they are consistently being asked to exhaust their resources. And what we also know about this kind of 10% of the population that's navigating court, is having a really hard time getting to court, we also know that they're typically not navigating one case, that instead they're actually navigating 2 or 3 cases. And so what that means is that every time we ask someone to appear court, and yes, of course, that's important, it is going to require so much more of that community to get to court. And so ultimately, what ends up happening is they're navigating all of these situations across all of these hearings, and they're doing it over and over and over again. And the reality for this population, this kind of 10% of the population, is that the threat of a bench warrant and returning to jail is not compelling for them. And I want us to sit and think about that, because as I was reflecting on this, that was a moment for me. If jail is not compelling for you to get to court, then what does that mean for the way that you're navigating or living? If jail is not destabilizing for you, if it's not a threat for you, then that means that you are likely navigating something that I am not navigating. You are likely navigating something I may never understand. And at that point, we have to understand then that this population is experiencing something completely different than the rest of us. We have to understand then that going in and out of jail is going to continue to make it even more challenging for this population to get any resource to get them to court. And ultimately, if we're going to think about this and really, really challenging ourselves to take an equity approach to pretrial, we really have to challenge ourselves to think about, is there even a need for punishing these individuals who are clearly navigating poverty and co-occurring concerns? And of course, if people are committing violence, if they're violating protective orders, yes, of course, there are spaces in which jail seems useful and thoughtful and important. But by and large, what we see across many jurisdictions of the 10% of folks that are revolving through the system over and over again on bench warrants, they're typically being picked up and charged with low-level misdemeanors, property offenses, even at the felony level, and other crimes that are not person crimes that are typically associated with poverty and cumulative disadvantage. And so ultimately, if these folks are experiencing something that we're not experiencing, we have to reconsider our expectations. We have to stop asking these folks to rise to the occasion and expect that they can do the same things that we do. They are experiencing a level of stress that might be impairing even just basic cognitive or an executive function, not even talking about concerns related to substance use or mental health. And so we have to think differently. We have to reset our expectations. We have to willing to give grace to these folks and really depersonalize their absence. And I think that's one of the things that we see across jurisdictions is that when these folks miss court, there's a enough of it is enough approach. And I understand how we get there. I totally do. And also, they're just navigating something that hopefully a lot of us will never navigate. And that means that we just need to depersonalize it. It isn't about them missing court or wanting to miss court or evade justice. It's really about these folks surviving. And so ultimately, we understand that there are lots of options that for releasing folks and keeping folks from being detained at arraignment. And while we like to see more and more ROR, we understand that there is more and more pretrial supervision that's happening, especially in a movement away from bail. And I totally appreciate that we want to have more ROR and instead move to pretrial supports. And this distinction between pretrial surveillance and pretrial support is really rethinking the need to punish people for not calling in or not coming to meetings during the pretrial phase when we might already be exhausting their resources to get to court. But in this population in particular, this 10% of population, it makes sense that we would not be using ROR, that in fact, they cannot get to court on their own, and they've proven that. And so instead, we may need to put more and more of this 10% of folks on pretrial. And we have to stop thinking about how we punish them all on pretrial and instead actually support them getting to court. And as we do more and more of this work, we're going to start to research it. And I think what's really important about the PET network is that we often elevate sites that don't actually have a lot of research behind them. And that's okay. Doing something that is not currently evidence-based or evidence-formed doesn't mean it's not worth doing. Innovation is always worth doing. And as researchers or as people who want to evaluate our own programs, we tend to think about these programs and think about measuring them in black and white and yes and no. And did somebody get to court? Did they not? Did they receive a bench warrant or did they not receive a bench warrant? And we have to think about this population that they may never reach 100% because they're just navigating something so complex that's unlikely to be fixed during the pretrial phase. And instead, as we move forward and think about evaluating these programs, we really have to be thinking about how we improve the rate of attendance over time rather than expecting perfection. And that ultimately, if every case go around that someone has, that they make it to 60%, and the next time they make it to 77, and the next time they make it to 88, this is an improvement. That is success. It's possible that we'll never get 100% from 100% of people, and that's okay. We want to make sure that what we're doing and as we're implementing innovation, that we're thinking about the progress that our people are making and giving them grace in the process. Ultimately, all of our goals today is to help people get to court and especially help people that are really navigating some of the most complex challenges of anyone that's navigating through the court process. And we understand to do that then really means that we need to address people's fundamental reasons why they're challenged to get to court. And with that, I'm excited to turn it back over to Kimberly.
Thank you so much, Shannon. And really excited as we've just unpacked some of the evidence to turn it over to our guests from New York City Criminal Justice Agency, coming from the Queens Supervised Release Program. We'll do a little switch up today on the agenda, but I would love to invite Kathy Pearson Brianna DiDomenico and Jackie Dodrell to come to the floor and share a little bit about the Queen's Supervised Release Program. Thank you so much for joining us.
Thank you, everyone. I'm not sure if you can hear me. I think we might be having some tech issues on our end.
Yes,
but can you hear me? Okay, perfect. Thank you. I think we're just getting our presentation up. Thank you guys so much.
I'm going to go ahead and get us started. Jackie was going to launch us off with sharing the slides. I think she might have missed that we're going a little early. So I'll get us started and she will jump in as soon as she can. Give me 1 second.
Kimberly, can we go ahead and share Jackie's slides for her and then
pull them up?
Thank you so much. We appreciate it.
Okay, can everyone hear me?
Yes, we can.
Great. Okay, so today we're going to be talking about our approach to support individuals in navigating the court system. Specifically, we're going to be speaking on our engagement strategies and procedural justice strategies for pretrial population here in New York City, Queens. My name is Jacqueline Dodrell. I'm a licensed social worker and currently Associate Director of Clinical Services with a supervised release. I've been with supervised release for approximately 4 years, and I'm joined by Kathy and Brianna, if you want to introduce yourself.
Hey, sure. I'm Kathy Pearson. I'm a licensed clinical social worker here in New York. I have been working for supervised release in Queens for 7 years. I started as a clinical supervisor when we were very small. We had about 6 case managers. And now am the one of the associate clinical directors here overseeing all of the work that we do.
Hi, everyone. It's great to be here with you all today. My name is Brianna DiDomenico, and I'm the Director of Court Operations and Administration with the Supervised Release Program. And I oversee everything that we do in court, as well as all of our quality control and statistical reporting. So great to be here with you all. Thanks so much.
Kimberly, can you go to the next slide, please? Great. So this program began with one main objective to being an alternative to bail program. So it's alternative to pretrial detention and supporting people in their communities, encouraging court appearance. So the main focus is exactly what we're speaking about today. There are 3 pillars to our program model, and one is individualized care. Each case manager collaborates with the clients and to create and identify goals that they have together mutually, and also to find barriers that could come up in achieving those goals. Our second pillar is having a cooperative process. So recognizing that the relationships that we have with our clients is really the key and driving force to making sure that we are able to work with them, to support them, and for them to have buy-in in what we're doing. And in that way, we can help them to clear some barriers, troubleshoot, and also get them to court and liaison with different court partners so that they can support on that end as well. And then the third pillar is just consideration for what is happening. So a lot of what was said in the last presentation, it's that consideration of the stress and the difficulty that it really is to be involved in criminal justice, to be involved with supervised release. And we really see procedural justice, the idea that fair process and how people's perception of that fairness really impacts the experience they have while attending court, going to supervised release. And so we keep that in mind in everything that we do. And so because of that, people see that we are understanding of their situation, and it creates that much more buy-in. It cements really the relationship between the case manager and also that client. Can you go to the next slide, please? Thank you. Kathy, I'm going to throw it to you for this one.
Yep. So I just want to run you through our timeline, how we've evolved with the times, and how we've grown and shifted as our clients needed us to. So in 2009, supervised release was launched in Queens as a pilot by CJA. So we created the model for supervised release in 2009, and in 2016, SRP was launched citywide. So each borough in New York City has their own SRP program, supervised release program, that operates with roughly the same, the same outline set forth to us by the mayor's office in conjunction with OCA. But we each have our own little twist and provide our own set of services to our participants. In a lot of change happened between 2016 and 2018. We were briefly operating in Manhattan. We stopped operating in Manhattan, and another program took that borough on, and we just really focused in on Queens. In 2008, we had the idea to launch a peer services program. So we hired our very first peer specialist at that point, and found that the work of a peer using their lived experience was incredibly powerful for our clients. As legislation for bail reform passed in 2019, we went ahead and recruited for a full peer program. So this included peer leadership. We hired a senior manager of peer services. We have peer supervisors on staff, and started recruiting for our peer specialist team too. Bail reform happened in 2019 legislation launched in 2020. A lot of things happened in 2020 for us, just like they did for many people. Bail reform happened, and immediately after that, COVID-19 happened. We all went home, and we saw our client instability grow. The needs of our clients changed within the city, which just became more and more vulnerable as a whole. We operated fully remote during that time. Court went remote during that time. Nobody was really seen in person, except for a select few. We were delivering phones in the community, meeting people's needs, coming into the office when we needed to, with protections and masks, but otherwise we were all at home. From there, we came back to work in late 2021, and have just continued growing since then. We've continued to meet the needs of our clients. And in 2023, we launched our court-based social worker program. This is a program I'll talk to you a bit more about a little later. And we began training our team on EPICS, which is a clinical tool that had never been done in pretrial services before until now. And now we're really focused on just continuing to increase our community presence for our participants. And next slide.
This slide is representative of our clients, and so it's a little bit of our demographics. In general, our clients stay about 3.4 months in SRP, and we always have approximately 2,500 clients currently active in the program. And if you look at the first bar, at the first graph, the total number of dockets is 7,198 in 2023. And keeping in mind also that some of these dockets are overlapping because certain people have multiple dockets or do become rearrested during that time. But generally the misdemeanor and felony in 2023 were approximately in the middle, 3,545 for misdemeanor and 3,627 for felony charges. If you look at the pie graph below for the ages, it shows a really big picture, and it also informed a lot of the work that we did. The biggest group is going to be 30 to 39, and our average client age is about 36 years old. And so after that big category of 30 to 39, everything else breaks out fairly evenly under 24, 25 to 29, 40 to 49, and then 50 plus. So these numbers of ages, it did help us to determine where we really need to put more of our efforts, because people who are in their middle ages are more likely to have family issues that they're dealing with, family court, employment services that they're looking for. And so it did help us with that. And if you look above at the bar graph, it shows our percentage of QSRP clients assessed as in need. And when we say in need, it's based on the intake process that we determine once the client comes in. We have 46.5% as in need, 41.5% as not in need, and 12% incomplete assessment. That 12% incomplete assessment is really important to highlight. The reason being is a lot of times that people are not able to come in and complete the intake. It is because they're dealing with high needs situations like homelessness, substance use, mental health, financial barriers, different things in their life that is preventing them from coming in and getting assessed for what kind of needs we might be able to help them with. And the last pie graph in the bottom is the 2023 breakdown of self-identified race. And so if you look down at it, we have 35% as Black, 24% as other, 18% unknown, 15% as white, 7% as Asian, and 1% as Indian, a large percentage. And it's important to keep in mind in these demographics that people are not always going to explain or say what they consider themselves to be. And there's a lot of reasons for why they might withhold that information. It could be just being uncomfortable disclosing, just distrust of the program, fear of the stigma, a lot of different reasons. But I did forget to mention one thing. If you go back to the bar graph, the in needs assessment, we do have 17 categories of in needs that we have offered to clients. And so it's different things related to benefits, ID documentation, treatment options, parenting courses, and we really do get creative. So if the client has unique needs, we try our very best to also try to find something that does work or something similar or equivalent. We can go to the next slide. Slide is 2024 snapshot. It's a little bit of information that we have gathered from current clients, now active clients, and it's after they have completed intake. And so if you look at the first number, about 33% of QSRP clients are assessed to be specialized track. These specialized track breaks down into a couple of different options, and sometimes they do overlap. So it's individuals with serious mental illness, interpartner violence, unhoused individuals, clients who have been identified to have more likelihood of SRP failure, failure to return to court, and then clients who have been selected by their case managers for specialized ethics approach. And so if you see the number next to it, what we're trying to show is we are making every effort to match the needs of what our clients are showing that is required. So we have 33% that have higher needs. We have 24% of staff that are currently licensed clinicians. And aside from that, we also have many, many more that have that hold MSWs, are in the process of gaining MSWs or mental health counseling licenses. If you look below that, we do have 23% of QSRP clients who are listed, self-identified listed as non-English for their primary language. And I think that really shows how quickly things change, because our 2023 data showed 19% for non-English as primary language. And so next to that, we have our stats for our QSRP staff. We are 32% bilingual. And so we are able to cover a lot of the clients that have bilingual needs. But even so, we still use language lines and other technology in order to bridge that gap. It doesn't mean that it's a perfect system, because it isn't, it would never be with technology to replace a person. But we make every effort. We also support the clients to communicate with their attorneys and advocate for themselves in court, to have bilingual services there so that they understand what's going on and what is expected of them. If you can go to the slide, please. This was fun. We set up a poll amongst our QSRP staff, and we asked them, what is the biggest barrier that clients are telling you is going on to getting to SRP, to getting to court? And this is the word cloud that came up for us. If you notice, a lot of the things are what we've all expect and what we already said. So transportation, mental health, work, family, fear, housing, employment, a lot of the similar things that we did expect, but it's good to also check in and make sure that nothing new is happening. Next slide, please. Okay. And using that feedback that we got from the staff, and also just feedback from data and numbers, we use all of that to implement engagement strategies that match the needs that are coming up over time. And in consideration also with changes in legislation, as Kathy said, the changes in legislation really drive a lot of the changes that happen, because there's different expectations for clients, there's different types of clients over time. And so we have to modify ourselves in accordance to that. And so what we offer is someone that's available to support them every step of the way, including in court, in the office, and in the community. And we do that through trauma-informed practices, by implementing court-based social workers, peer services, the EPICS program that we're going to go into a little bit later on, group work, and a large amount of community engagement. Thank you. Kick it back to Kathy.
Hey, yeah, so I'm going to talk a little bit about what our engagement looks like in the court. I'm going to flip these two bullets a little bit to talk to you guys about what the client, paint the picture of what a client experiences immediately following their arraignment. I want to first introduce our court reps to you. Our court reps are a group of individuals who are the very first people that clients meet upon their release. If they're released to SRP, a court rep immediately follows them out of the courtroom and meets with them very briefly. It's usually 5, not even 10 minutes, I would say. But it is a time of deep vulnerability for the clients. It's a time when people are feeling really hungry. They're feeling really cold, physically cold. They're feeling really confused about what they're supposed to do next, and kind of usually a little bit unsure of what they heard in court. So this is when our court rep team really steps in. So they meet with the clients very briefly. They deliver concise and clear information to do what we call orienting the clients to the program. So they talk through where the client needs to be and when. They talk about what we will expect of them when they get to the office. And they also really look and do a real quick assessment for barriers to attending the next day. So these barriers may look like work or childcare. They may look like mental health or substance use or housing instability, or even like the client was about to get on a plane to leave when they got arrested. So they're going to get on a plane to leave immediately after this. And at that point, they're going to immediately call in a social worker to do an assessment and engagement with the client. So that's when our social workers step in. Our social workers, we launched our court-based social work program really in 2021, when right when we got back from the pandemic. We started with a rotation of staff that we already had, who were going to court every day. One social worker and one peer specialist who were there engaging clients outside of court. This worked really well. So in 2023, we really developed the court-based social work program out further. We actually were able to hire licensed social workers to provide this service in court for both shifts. So the court-based social workers work hand in hand with our court reps to provide support and engagement for all of our clients. One of the primary roles of the court-based social worker is to meet with the clients immediately after their orientation with the court reps. They complete full intake so that the client's not expected to return to our office the next day, but they also provide them with some tangible things that they need, like shoelaces, sweatshirts, clean socks, toiletries, snacks, rain ponchos if it's raining outside. And the purpose of this engagement is really just to build connection with people and give them a boost. It helps clients understand what they need to do in regards to court and compliance in our program. And in some ways, one of the most important things that they do is just engaging clients, showing them that we're a friendly face and that we're really here to support them. Our court reps and our court-based social workers also circulate all of our court parts in the day shift. So the court reps go from courtroom to courtroom, they talk to attorneys, they talk to participants, and they collect court results such as like our graduated responses. So if a judge lowers the client supervision level, or maybe a judge grants ROR to someone who has done well in the program. Our court-based social workers also assist with many of these things while meeting clients. They'll kind of stop by, check in on people, make sure that they're comfortable, that they don't have any questions, that they understand where they need to be. And both our court reps and court-based social workers operate both shifts, day and night shifts. So we're staffed from 9 a.m. until court goes down at 1 a.m. And next slide.
Once they go from arraignments and come into our office, we continue that same warm handoff, and we make sure that the clients are offered things that they need for in the moment. So any kind of snacks, Metro cards, any hygiene items, even more high level things like Narcan kits and clothing. We actually have created a clothing closet, and it was based entirely on the staff who wanted it for their clients who were showing up underdressed or not dressed appropriately for the weather. And so we also try in the office to show them that this is a place where we are trying to support them. We are trying to be there for them and make sure that they have what they need to be able to focus on what they have at hand, which is the court case. We also train the staff to be trauma informed and trauma aware. And so that's having trauma awareness first and foremost, recognizing signs of trauma via the assessment, via their clinical judgment. And we do offer different sorts of services depending on what's happening. One good example is Kathy brought up the youth and how youth were brought into our program as clients after legislation occurred. And so one of the things that we offer specifically to the youth is family counseling to help repair some of the things that were damaged by being in court. The staff is also required and have voluntary specialized training, and it can be in a variety of topics, anywhere from harm reduction, de-escalation, motivational interviewing, anything that will help them understand what the client might be experiencing, be able to assess what's happening, and be able to provide appropriate services. Other things that related to trauma informed that we infuse into the program is language and how things are documented, how to debrief with your supervisor so that the weight of everything that is happening doesn't lie just with the staff. And then also just continuous assessment, always looking at the things that we're doing, taking into account the feedback that the staff is giving us, because there's always room for improvement, and they're the ones that are seeing the clients first and foremost. So they're going to know what modifications might be needed. A really good example that Brianna spearheaded is the modification for remote supervision. So clients were saying, I have work, I have school, I have my life pretty set up. This is interfering with that. I want to attend. I want to do what I have to do. I don't want everything else to fall apart. And so we did come up with a policy to be able to verify work and school. And that way we can have remote services for those clients and still support them in a different way that is still supportive of the stability that they already have. We can go to the next slide. Assessments are done at intake. And the assessment process was changed in 2017 to review and update a couple of things that needed to be aligned more closely with current evidence-based approaches. And it's related to mental health, related to substance use, related to suicidality. And so those assessments are always being reviewed, not just for which questions they're asked, but the way that we're implementing and the way that we're using them afterwards. For example, if a client assesses for a small amount of substance, but not to the level of high levels of treatment, then staff is aware that they need to do a brief intervention, explain to the client what they scored in, because it's their information too, and then what consequences that might have, what signs it might point to. Age-appropriate assessments were also implemented for the 16 and 17-year-olds. And then EPICS is a really big one. The EPIC's model of supervision, it engages participants in more structured sessions. It identifies behaviors that have negative impacts and creates and supports utilizing skills that are sustainable. These are things that we always did, that we have always done, but EPICS created a framework, it created a language, and it created a structure for staff to really be able to write about it, think about it, and also discuss with their supervisors on it. And the last thing that I'm going to speak about in the office is group work, which has really exploded this year, which great thanks to one of our associate clinical directors. She created a much larger group where before we had one main group, anger management, and we saw a great need for clients to attend other types of groups. And so we began implementing navigating the Latino community, job search, interview, art therapy, and various other recovery and healing groups. And they've been pretty successful. And so we're continuing and looking forward to growing that even more. Just the next slide. And Kathy, this is you.
Hey, yeah, so in the now, what we're really focusing on, our 2024 goals is really doubling down on our community work. We want to really start meeting clients more where they're at, and we're doing that in a couple of ways. So we've started hosting weekly partnership presentations from local organizations that our clients could benefit from. So we're calling these Partnership Tuesdays. This is another shout out to Agnes. I think she's really done a great job spearheading that and getting the ball rolling on that. But we're really setting up direct connections and linkages with other organizations to ensure that we're able to get referrals made and seen by people and organizations that are best suited to serve our clients. Next up is our community space. So I don't know if anybody in here is from or familiar with New York, but retail level space is really coveted and special. We recently, as of March 1st, opened up our new retail level space that's directly across the street from the court. So this is something that you can see in the photo. It has CJ branding outside. It's right there. You can't miss us. We are no longer hidden away in 4th, 5th, 8th floors. We are right in the community and increased visibility and access. And then lastly, peer services. So I spoke about our launch of peer services when I discussed the timeline, but I'm happy to say that we, in my opinion, have one of the most effective peer services in the ATI game in New York City. Our peer specialist is a person who has lived experience and is trained to use that lived experience to support individuals and meet their needs and goals. So this is a completely voluntary service for our participants, but we do have specific touch points for our peers to meet them. So at the point of rearrest, a client will meet a peer. If anyone's charged with a violent felony, or if a judge mandates mandatory programming, people automatically meet with peers and are offered this service. Next slide.
And so we gathered both data, statistical facts, and anecdotal feedback in order to understand really what our impact is and where we need to go. And this is the information that we got when we asked about our impact. The first quote is from one of our court-based social workers, and she says, "Often clients are released in vulnerable conditions, and immediate support ensures their most important needs can be met. Having support on the front line ensures clients do not fall through the cracks and can have their initial intakes completed on the spot." It's a lot of what Kathy was speaking about, the importance of that initial connection and how reaching them in that crucial time can be a turning point for us and for them, our relationship. The next quote is, well, it's not a quote, it's a story that a client has agreed to share. And it's from a current QSRP client standing there before a grand jury. Anthony, all names have been changed. Anthony experienced a profound shift. He shares with his CCM, which is clinical case manager, "I feel like I'm taking my life back. This newfound strength not only encouraged him to re-engage with therapy, but also equipped him to confront his anxiety head on. The initial months following the stabbing were marred by fear and reluctance to seek help. However, his CCM's relentless support, utilizing CBT and motivational interviewing, guided Anthony through the darkness of his trauma." Our last quote is from Juliet Haji Noor. She's the supervising attorney at Legal Aid Society here in Queens. And she says, I have had the pleasure of working side by side with staff members of the Queens Supervised Release Program for a number of years. In our quest for decarceration of our clients at Rikers Island, supervised release has played a vital role, especially in the time since monumentally transformative bail reform took effect in 2020. The support that supervised release has provided us as advocates has been immeasurable.
So we'd like to share just some recap statistics of over the last couple of years, particularly some of the gradational changes post bail reform here in New York. So if you see on the left-hand side of the screen, we have our rearrest rates. Now the percentages that are before you are the percentage of clients that have not been rearrested while in the program. So you see in 2019, we had 81% of our clients had not been rearrested while in the program. In 2020, it was a little over 78%. In 2023, it was just about 78%. So currently, we're at about the same rate as last year, where it's about 78% of our clients have not been rearrested while in the program. And we really want to contribute that as a huge success, because while there is a small percentage of folks that have been rearrested while they're in the program, as Jackie mentioned, at any point in our timeline, we have about 2,500 active clients. And we have clients coming in from all walks of life with all different needs, a lot of co-occurring needs, compounding needs. And we have really enhanced our staff to be able to support them to try to ensure their return to court and reduce rearrest rates. So while some of the legislative changes have really impacted the program, we're really excited and proud of the fact that our rearrest rates have still remained low. And additionally, on the right-hand side of the screen, you'll see some of our successful versus unsuccessful exit rates. So in 2023, we had about 3/4 of our exits, meaning clients that were no longer in the program and have since been exited from the program. About 3/4 of them were successful, which was almost about 4,000. And out of our successful exits, the vast majority of those were because their cases were resolved and cases resolved favorably. The highest number of case dispositions, a little over 1,500, were because the case was dismissed. So if you think about it, these folks, instead of having bail set and being detained pre-trial, they were released under supervision. They're at liberty. They're able to get support. They're able to get clinical services if they need, and they're able to stay at liberty while they're fighting their case. And about 44% of the 75% of our successful exits actually had their cases dismissed. So if you think all of those people might have been detained pre-trial for a case that was wound up probably being thrown out. So we're really happy to be able to serve those clients. Right underneath that, a little under 1,500 was pled guilty. And we had most of our folks had pled guilty to either a violation, which, as I'm sure everyone knows, is not a crime. It's a violation of the law, not a misdemeanor, not a felony, or a misdemeanor, usually petty larceny or 220-03, which in New York is a misdemeanor possession of a substance. We also had the third highest rate was ACD, adjourned in contemplation of dismissal, where if you stay out of trouble for 6 months to a year, the case gets thrown out. So the vast majority of the case dispositions were in dismissal or pled guilty to a low-level offense, which is great. We also had about 10% of our successful exits actually get ROR'd. So the judge said, you've been doing really well in the program, and we're actually going to take you off of supervised release and instead release you on your own recognizance because of your ongoing compliance, which was great. And we did have about the remaining 25% were classified as unsuccessful exits. Out of the unsuccessful exits, most of those were individuals that were exited due to having an active warrant that they had never since returned on. And based on our stakeholders and our funders, we do exit clients once they have a warrant active for 30 days and do not return on it. So most of our unsuccessful exits were due to the warrant. There are also other smaller percentages of individuals that are exited because they have bail set or are remanded on our docket, most often because of a rearrest that has fallen suit. So maybe they're in supervised release on one case, they get rearrested and get bail set on their rearrest docket, and in order to ensure that they get credit for any time served on all of their dockets, usually the judge will set like a dollar bail or some amount of bail on any previously pending docket. There are also a small amount, a small percentage of folks that are, or we call it administrative discharge, which is essentially the case is either removed to family court, so it's actually taken out of criminal court overall, or unfortunately we have had clients that have passed away, and as a result, their cases are considered abated by death. But overall, despite the growth of the program, we're really excited to see the low number of rearrests as well as the high percentage of successful exits while in the program.
And looking ahead for the next steps, we're continuing to use the most up-to-date research. And currently we are looking at results from a research study that we did based on remote versus in-person supervision. And we're hoping to potentially create some policy change related to that. And then we're also looking to increase community-based work by a lot. Kathy could sit here and say it forever, but the community work is really important to QSRP. And so we're looking to become more intensive. We're looking to have more people reach clients where they're at physically. And through that, we're looking for them to follow clients in the community, to help them to navigate court, navigate their lives. And it's something that we've always done. It's always been a part of QSRP, but we're looking to ramp it up a little bit more in the next couple of years. Another thing is organizational partnership. We've talked a lot about how we host new agencies, but we are looking to always host more people and partner with more people in the community so that we can create our own network for our clients. It can be a network, or it can be a safety net, I guess, for clients to go to. And in general, expanding our court presence. So the court-based social worker program has already expanded. We're looking to review those roles and duties and expand it even further. So those are our next goals. Thank you for your time.
Thank you so much, Jackie, Kathy, Brianna. I cannot overstate how incredible your work is. And it's wonderful to see the impact that it has on the folks that you work with. And so, yeah, I just thank you so much for sharing about your work, and we'll come back to you in a little bit. But first, we want to turn it over to our panelists from Charleston County, South Carolina today. We have Leanne Atkins from 180 Place, William Malcolm from the Sheriff's Office, and Dennis Pepla from the Mental Health Center. And I see, right, lovely, I see your faces. Just want to check and make sure we can hear you too.
Can you hear me?
Yes, we can.
Okay,
Yes.
I think I'll be going first, and I'm watching the time, so I'm going to really skip through a bit of an introduction here, but I assume at the beginning there was a bio on all of us, and so I am Leanne Atkins. I work at 180 Place. It is the homeless shelter in Charleston, South Carolina. We're a nonprofit agency, and we're also the area's largest provider of homeless services. I work there in legal services, and we help people in the shelter and in the homeless community with their civil legal needs that can help overcome the barriers to housing. We all know here at 180 Place that chronic homelessness can greatly increase the chance that a person becomes involved with the criminal justice system. And I think that most of the people on this call are aware of that fact as well. Relating to the topic of the webinar that we're listening to today, helping those who are most likely to miss court, we know that homelessness and other chronic conditions can cause difficulty getting to any appointment or just a meeting or certainly a court appearance. And but the consequences are greatest whenever you're missing a court appearance. And there are many reasons for this. Simply trying to find a safe place to sleep at night, food to eat, a means of finding enough money to meet your daily needs. The prioritizing of an appearance in court or even just a doctor's appointment becomes more of a luxury whenever you are living in such a condition. My fellow representatives from the local mental health agency, the county substance use disorder agency, as well as others here, certainly understand these challenges for their clients as well. And several years ago, we discussed the data coming out of our own Charleston County CJCC. All of us happen to be very involved and active with the CJCC. Our CJCC tracks data from many sources, including law enforcement, the courts, the detention center, and other related sources. And back in around 2018, we started noticing there were very high numbers of jail bed days consumed by these, what we called familiar faces at the time, people who were cycling in and out of the detention center on basically low-level charges. At one point in 2018, our data showed that roughly 94,000 jail bed days accounted for 20% of all jail admissions for the familiar face population, which was pretty startling. And these are individuals being booked repeatedly for mostly low-level crimes against public order, such as public intoxication, trespassing, disorderly conduct. And we know that these charges can actually be symptomatic of some underlying conditions, such as chronic homelessness, serious mental health conditions, and substance use disorders. So this group, the people on this call today and others in various agencies, started meeting informally to address these conditions and to talk about ways that we might interrupt this cycle of incarceration among the familiar faces. And there was a benefit just of us getting together in the same room. We got to know each other's agencies better. We got to be more familiar with exactly what each agency could do with our clients. This exercise alone, I think, made us more effective, but we knew that we wanted to do more, and we wanted to put a process in place that could case manage these familiar faces on a larger scale and would allow multiple agencies to work together to help them. And just as important, we wanted this process to be able to be duplicated elsewhere. And so we devoted extra time to this. We all had busy full-time occupations, but this is something that we did and continue to do regularly in addition to our jobs. And this became, in effect, the Charleston County's Most Visible Persons program. And I'm going to throw it to Dennis Puebla to tell you a little more about what that is exactly.
Oh, hello, everyone. My name's Dennis Puebla, and I am the Director of Special Operations here at the Charleston Dorchester Mental Health Center. And thanks, Leanne. And so, as Leanne mentioned, we came together from a bunch of different agencies to spearhead an effort to address our more visible people in the community who were coming to the attention of law enforcement, our local hospitals, our mental health center, other partners, shelters, and we identified a group that was over a year's period of time had 4 or more detention stays. And we started engaging them within the detention center. We developed a sort of like a short version of an intake form, orientated them to what to expect upon their release from the detention center, the services that were available in the community. And at that point, worked on the engagement of them in services. And as we know, the biggest challenge that we had was, them necessarily not being ready to participate in services. We would work on engaging them. We had an outreach team from the Department of Mental Health. We had other providers in the community who would look to connect them to services. We had as far as the stakeholders in the program, we had as many as 40. And this included our unsheltered outreach teams, both at 180 and the Hope Center and the Navigation Center. We had a law enforcement buy-in from our local law enforcement here in Charleston, North Charleston PD, the Sheriff's Office, Mount Pleasant. They had their own street teams, and ultimately the goal was to sort of wrap these familiar faces with familiar faces who would encounter them out in the community. We also had participants from the municipal courts, probate court, our specialty courts, which is both our mental health and our drug courts. We have a veterans court, and we also have a homeless court. We had participants from the solicitor's office, our public defender's office, and as Leanne mentioned, we all had other jobs that we came together for this one cause. So some of the challenges that we had sort of implementing this program was, as I mentioned, a lot of the folks that we were working with were just not ready to sort of engage in services. So a lot of times we were essentially planting a seed and sort of circling them back. We would see them in the community with our outreach team and trying to work with them on coming in and coming into services. And I can share one story of someone that we had worked with. And it was about over the course of a year. We worked with her when she was transitioning from the detention center, engaged her in one of our crisis stabilization units, which is a 10-bed voluntary stabilization unit to get her sort of situated on medications, worked with her engagement as we were waiting to place her into a drug and alcohol treatment program, which we were successfully able to do, and then worked on her discharge planning and eventually working toward getting her housed. I think the most important thing, and I think the measure of success that we have with this program, is that they are not returning to jail. So Leanne mentioned roughly about the percentage of 20 to 30% making up our jail population when we got this started. And right now, not an exact number, but we're probably in the low percentiles, single digit percentiles, in terms of our familiar faces who make up our jail population. That is all I have, and I will turn it over to William.
Thanks, Dennis. My name is William Malcolm, and I am a clinical social worker, and I work for the Charleston County Sheriff's Office. So the Sheriff's Office is the law enforcement agency in the unincorporated parts of Charleston County, and we also run the Charleston County Detention Center, which is called the Sheriff Al Keenan Detention Center. I think that I just want to kind of be clear, like the difference between the supervised release program in Queens is in what we do is we have this very informal case management process where it's actually different providers. It's all the different people that are a part of the community. And so it's not just one provider that's doing all the case management. It's like the people that we have in this MVP population are maybe served by like all of us in some kind of way or other, but this is a work group in which we're able to kind of discuss their case and everything that's going on with them. And so about 2 years ago, I joined the Sheriff's Office, and I actually I worked in Brooklyn, New York. I worked for the agency that does the supervised release in Manhattan. I worked at cases, but I moved back to Charleston, and I started working here. And I became involved with this group, and I kind of I chair the meeting each month because I'm in the jail, and so I have access to them in this facility. And so, right now we have about 100 people on the list currently, and that kind of changes from month to month based on their arrest each month. So if you could just move the next slide, Kim, that'd be great. And so as you can see, like most of the charges are kind of low-level misdemeanor charges that, you know, these are people that are kind of cycling in and out of jail. And so essentially they have to be the lower level charges, because in order to keep going in and out, you have to be only in for 20 to 30 days at a time. And so, you know, these are the people that are kind of like the highest users of jail services, if we want to talk about it that way. And they're also the highest users of EMS, highest users of a hospital, the highest users of homeless services, of court. And so they're kind of using all of these resources in our community. And the way that we've kind of approached it is like, well, let's talk about the people that are kind of the most difficult for all of us, because we all know them. And I think that, you know, one of the things that can be very different, I think, that we do is we actually have law enforcement from the community that's like, oh yeah, we saw this person yesterday and they're down on King Street. And it seems like, you know, last month it seemed like they were maybe drinking a lot, but this month it seems like they might be using drugs. And so we're getting like these, you know, kind of snippets from a lot of different people that are kind of coming into contact with them. There may be, well, they were supposed to make an appointment with the mental health facility, but they missed it. If you see them next, can you actually bring them here? And so all of these little conversations go on in which we are coordinating these population that are the hardest to engage in the community, right? So, you know, the thing about Charleston is there's 400,000 people here, but it feels kind of like a small town sometimes. So once, you know, I kind of understood like who is here and who's there, I could be like, oh, well, I think, you know, maybe see if Leanne knows this person. And so I can just reach out to those people separately outside the group if I need like a specific question. So I just want to kind of talk about like some of the basic data that we have of the current MVPs. So currently there are 100 individuals. 39 of those people are currently detained in our detention center and 61 are not. There are 7 people that are in our detention facility that are not eligible. So we decided that violent charges made people ineligible for this program. Okay. And as of 5/1/23 to April 30th of 2024, 80 are male, 20 are female, 65 are Black, and 35 are white. And so, you know, this coordination that happens on a regular basis is kind of just keeps improving outcomes. People basically fall off the list. That's the whole point, is we're getting people to fall off the list and reduce the list itself. I mean, I think anecdotally, a year or two ago, it was probably around 100, 120, and now we're down around 100. We don't have specific data about success necessarily that we're going to share, but I think that there are less people on the list, and I do think that just the conversation and communication is the real key where we're improving their outcomes. So what came out of this MVP group was that, you know, one of the main problems is still that these people just do not have housing. And so through the MacArthur Foundation, Charleston County applied for a grant through the Just Home Project. And so that the Just Home Project has a lot of different pieces to it, but the main piece is that we started a transitional housing project, and it is currently at 180 Place. It's a home that's outside of the shelter, and it's for this specific population when they get out of jail. And so essentially, when somebody is in the jail, I speak with them, or my staff speaks with them and says, hey, like, we know you're on this MVP list. It seems like you don't have housing. Do you want to go to this program? And we have to kind of explain to them, hey, this is a little different than shelter. It's you are going to just be sharing a room, but it's in a house. They have a kitchen. You're able to come and go as you please. It's not kind of this, there's not the same kind of rules as the shelter. And it's also just, it's more private than the shelter. And I can get you there as soon as you get out of jail. And so we just started about a month ago in getting those people out. Currently, we have 2 people in the program now, and we're working on getting more and more people that are in the jail and getting them out. The other piece of this is that we've also said, hey, if someone is not currently in the jail, but they are on the MVP list, they could just come from the street into that program. And hopefully just being in that program will avoid their next rearrest, or at least reduce the amount that they're going to get rearrested. So hopefully we're going to get it fully filled up in the next couple of weeks. And the idea is that this is just a transitional residence. Hopefully people will stay there 90 to 120 days. But we are still just kind of in the infancy of that project. So I do want to leave it open for any other questions if people have them. I don't see any right now, but I don't know if Leanne or Dennis think that I need to add anything else.
The only thing I would add, William, is that once someone is in that transitional housing at 180 Place, immediately housing managers are working with them to secure stable housing. And that would be using the Housing First model. I remember receiving, in fact, I have it in front of me some time back, some literature from the Urban Institute that said that the Housing First approach is really the only strategy proven to break the homelessness jail cycle. So it's critically important that we get people stably housed, move them out of this transitional housing into something more stable. And we do this utilizing primarily permanent supportive housing. We know from experience that our MVPs generally qualify for this, and that provides ongoing case management along with independent housing from this point forward if need be. So that's a critical part of creating a permanent solution to this cycle.
Thank you so much, Charleston. And thank you so much to CJ as well. I mean, I think, you know, the work that you all are doing here is really quite fantastic. And, you know, I think the ability for you all to think about this population and what they're moving through and then how to focus on, I think is really incredible. I mean, one of the things that I heard, you know, from William, right, is that like, this doesn't maybe look like the Queen's supervised release program. And I think that's kind of the point here, right? That there, you could have a very, very large jurisdiction like New York or Queens, and you could do something very robust like Queen's supervised release. Or you could have something kind of on a smaller scale like you all in Charleston and kind of really doing that work there. And William, I appreciate that, like, it's a big city that sometimes feels like a small city. Like, I think that's right. And I think that's true amongst this population in particular. And so I know, you know, for the different jurisdictions that are out there, I think what both of your sites showcase is that it doesn't matter how small or how big you are, that this work can be done and it can be coordinated and you can see really positive results, even if it's just one step at a time. And so I know that there are a few questions from the chat that I just want to make sure that were answered. I see that thankfully Brianna was able to answer some of those questions, but I see a few people here and I'm just going to give them a little bit of space to ask a question. I see that Brandon Walker had their hand up, so I just wanted to give you space to be able to ask your question. Okay. I also see that perhaps Shannon, Catherine, or Aaron also had questions. I'm not sure if maybe those are also errors too. But I think, one of the questions that I had really here is that, certainly the success of both of these programs was really about is really about, getting folks to court. But do you see there being any other metrics of success? Like, is there anything else that you want to see from these folks as well?
So I'll answer that for me. I have kind of a low bar, I guess, is like, I think about days in jail or days in an institution, and if I can reduce the amount of days that someone's in our institution. I work here, and I don't think anybody should be here.
Right.
I don't, especially this kind of population, like, they're not best served in a jail. And if I can reduce the amount of days that they're here in our facility, that's the success. And because, I would love that these people change everything about who they are and change every piece of their life to get it back together. But I know that that's not how things change and how the process works. But if I can reduce the amount of days they spend in this jail, that's a success.
Yeah, I can super appreciate that. I mean, ultimately, we know that even one single day detained can have some collateral consequences for folks. And we know that even if jail, which is very sad, even if jail is not actually destabilizing for this population, it is a barrier to getting resources, right? Like, that is a full stop there. And I wonder, for Brianna and Kathy, for you folks, like, yes, getting to court is what we want to see, and you have incredible numbers of people who have gotten to court. But do you see any other success or any other metrics that you hope for folks?
You want to start, Brianna?
Sure, no problem. I saw we both unmuted at the same time. I think from like a court and an admin perspective, we want to see low rearrest rates. We want to see, of course, low rates of warrants being issued, and kind of what we would consider maybe like a pretrial failure. So a rearrest, particularly a rearrest maybe on a felony or a rearrest on a violent felony offense. We want to see people coming back to court and not getting warrants issued. So definitely like low measures of any kind of pretrial failure or reintroduction to the criminal justice system. And then from a non-clinical person, of course, seeing like connections to services when needed. And then there's where I'll kind of pass it off to Kathy for her expertise.
Yeah, I feel like we measure so many things actively in supervised release. Truly, like, we're looking at clients and participants and their engagement in the program from so many different angles. It's something that I'm looking forward to, that one of our other directors is working on with other departments, is like a client satisfaction survey at the end. Like, I from a social work lens, I want to make sure that we're hitting what we need to hit and that we're providing the support to people that they need, because I really think the judges, the court reps, our court-based social workers, our team and their initial intake are seeing clients in the most vulnerable position that they could ever be in many times. And I just think it's really important that part of our role is to make people feel comfortable and understood, and less anxious and less scared.
I appreciate that. I know that we're at time, but there is one other question that I know, has come up before here. And if we have just a few more minutes to just answer this, what we see a lot, particularly amongst this population, right, is that this population, I think William put that up too, that like a lot of low level offense types, right, they are cycling, but there is a lot of community pressure related to this population in particular. And thinking about kind of business owners and other people that are kind of applying pressure to the court system and to supervised release areas or these support networks, kind of how do you navigate that kind of pressure from the community about this particular population when you're trying to keep them out and perhaps the community wants you to do something different?
I can try to answer, speaking through a lens of someone who works with the homeless population. I think that whenever the public is being put off by this presence around them. Often it is the homelessness. It's that there is no place for them to go except to be in the public realm. And so again, that housing first model of working on housing, getting someone safe and secure in their own home takes them out of the public view so much. And it allows them to then recuperate, work on these things that they need to do to deal with their conditions. So the answer, in my opinion, would just be we need to do the work.
Mm-hmm. Totally. Any other thoughts from others here about how to navigate community pressures?
And Shannon, I'll add that I think engaging the community and the business owners and sort of educating them around who we are and what we're doing, and it's just like there's not a response, there is a response, and especially with our law enforcement, they have a lot of pressure because sometimes there's victims of crime. And so that has to be addressed, and restitution, but more it's, they're seen as a nuisance. And I think knowing the type of efforts that are being made, the fact that folks are going out to the encampments and we're sort of boots on the ground on the street, trying to connect with these folks, sort of direct them into services. And I think engaging them on certain community panels and hearing their voice and being able to give them answers about the services that are available and the efforts that we're making.
Dennis, I think that's really important. I think the thoughtfulness is that we're not doing nothing. We are doing something. And it's just really about a matter of communicating what it is that we're doing, right? That we're kind of getting to the root cause of this, and also educating community members and business owners in particular, like why jail is not going to help us get to the root cause too, right? And I think, it sounds like that's kind of what the work that you're doing.
Yes.
Yeah, that's awesome.
Yeah, I'll share that I actually had to do this I want to say about 2 months ago, where it was a high profile case of one of these people, and he was in the news, and it was kind of an arson case, and people were pretty outraged in this neighborhood. And there was a community meeting where I had to get up and say, hey, these are the things that we're doing. And then the police department had to get up and they were like, hey, this is what we're doing. And so there was like this discussion like, hey, by the way, we're just not listening. We're doing A, B, C, D through Z. And we're going to keep doing them. Whether or not he was like in the community or in the jail, et cetera. So yeah, I mean, we literally just had to do that. And I think that just happens sometimes where, I think the people in the community were like, they understood once I was there and once other people were there to say, hey, like, we are trying to solve these problems and we're trying to help these people in a meaningful way.
That's right.
While also like, we understand you are very concerned about public safety and your streets and your children. And they had some valid concerns, but at least just being in front of them and talking to them, I think it eased a lot of their concerns. So.
And Shannon, I think like you and a lot of others have shared, it's really about communication and education to other court partners that maybe have a different perspective, or other community holders that have a different perspective. Just really sharing what the challenges are for these individuals, what we're doing to help them, doing panels like this, doing interviews and meetings and trainings and kind of ongoing education to a whole host of folks to kind of explain what the challenges we notice are, what we're doing to kind of help them, and then ultimately try to get support and resources to be able to do more to really tackle and kind of resolve those issues at hand.
Yeah, and I appreciate, I think, even in your presentation, the voice, like, even though it is anecdotal, the voice of people who have gone there saying like, this was helpful, like, I needed this, thank you, right? Like, I think the ability to also elevate people who are most impacted, and also perhaps having them tell the story to community members, like, hi, it's me, I'm going through this, and like, please offer a little grace here. I think, and perhaps there's a way that as, you know, William and Dennis and all of you as stakeholders are presenting to different other stakeholders, that it also is including people who have gone through these programs to also vouch for themselves, to saying like, if you just give us a little bit of space, like this is what it could look like. And I really appreciate the storytelling aspect, because as a trained researcher, I love data, but sometimes data is just not very compelling. And then it's really more of the stories that become the compelling part of how we kind of see the humanity in each other, frankly. With that, I so appreciate everyone hanging on for an extra 6 minutes in their day. I think the work that, you know, CJA and Charleston are doing in both these programs is comprehensive and thoughtful and intentional and important. And it's really about engaging this very small population of people who have very extreme needs, who are very vulnerable, in ways that are just far more comprehensive than I think we originally think about from a court perspective. But certainly if the end of the day, the goal is to help people get to court, then I think ultimately we have to think about doing something different. And so with that, Kimberly, I'll turn it over to you to close us out.
Thanks, Shannon. I will share my screen really briefly and wrap us up. Thank you again to our panelists. Thank you, William, Leanne, Dennis, Jackie, Brianna, Kathy. Thank you so much for sharing about your work. As Shannon said, it's comprehensive, it's thought-provoking, it's compassionate. And as Brianna mentioned, education is a huge part of how we make a difference. And that is the part of this series that we love. And so even this topic today was birthed out of some responses from the last series of what people wanted to learn more about. And so with that, I will mention again that we love to get your feedback about how this work, how this information is relevant and helpful or useful to you. So after we close out today, you will receive a survey link. We encourage you to give us your feedback. Let us know what you would like to learn more about, who you would like to learn from. So we highly encourage you to fill out that survey. You will also receive a package of resources. We'll send out the slide decks from today. We will send out some overviews just of both programs. So you can just have a quick snapshot of what each program is doing. We'll also include the recording from today, the Pet Network's Equity in Action tool to help you think about how to increase equity in your own sites, and a little bit about the research that we do. And so thank you so much. Thank you to our panelists. Thank you, Shannon. And thank you all of you for joining us today. And we hope to see you again.